All right. Welcome to today's webinar, part of the new laws affecting subcontractors in California series, sponsored by Bay Area Chapter ASA, ASA LA Orange County Inland Empire, ASA Capital City, ASA California, ASA San Diego County Chapter, and Redwood Empire Chapter of ASA. Today's webinar is going to treat the top 20 laws that will affect California subcontractors starting January 1st, 2013. If you have questions during today's webinar, please use the chat function in the control panel on your screen. Today's webinar will be presented by Dan McLennon of McLennon Law Corp. Corporation in San Francisco. And Dan McLennon is the ASA California Government Relations Chair. He has more than 25 years of experience representing subcontractors, suppliers, and other firms in cases involving indemnity, insurance, mechanics liens, and this experience has resulted in the resolution of hundreds of cases through mediation, arbitration, and trial. He has been awarded Martindale Hubbell's AV rating, the highest rating in legal ability and ethics, and glad to say he is a frequent author and speaker for ASA and other construction industry trade associations. Thank you, Dan.
Well, thank you, Dave. It's good to be with everybody. I see in the registration list a number of old friends and a number of new friends. Welcome, everybody. And I'm excited about the election results last night. Would love to spend all morning talking about that, but we're going to have to refrain. There is a little bit of a tidbit that we'll talk about as we get going. You're going to probably have some questions about the bills that are already enacted and going into effect in January. And if we don't cover them, or if we don't cover them in enough detail, go ahead and email me. My email here is right on the front page. Go ahead and get that down. I'll have that available to you again at the end, but it's dmclennon@mclennonlaw.com, and I'm happy to answer any questions you have. If you want a copy of the slides when we're done, just pop me an email and I'll be glad to send you the slide deck. The other thing is that if you're not on my email list, we do law notes, which gives updates on legal changes, and I have a law note just about ready to be published that will give an executive summary of all the laws that we're going to be talking about today with links to the text of the bill themselves. So that will be available to you. Just let me know if you want it. As we go along, you have your little chat box. I'll try to keep my eye open for questions. This is a pretty difficult format for someone who likes to look people in the eye and have conversation with them, and I will welcome your questions so that I know that you're there and I'm not putting you too much to sleep. I will try to keep this moving pretty quickly. If we can get done in an hour, that will be good. Somewhere between an hour and a half, probably. All right, let's go to the first slide, and that is about me, which we will skip since Dave just went through that. A tidbit about the election results. This is news for California. It hasn't happened in 80 years where one party has taken control of both houses and the governor's office at once. Now that has happened as of last night's elections. What you see is that this win hands Democrats control of both houses, but it also, since they have a supermajority now, gives the legislature the ability to override a veto if Governor Brown was so inclined to veto a bill that comes out. This is going to be one crazy ledge session. Ladies and gentlemen, hold your hats, because there's going to be a lot of opportunities and a lot of strange things coming out of Sacramento in the coming 2 years. We do have 30 new legislators coming in, and so that will add some questions to the mix. Now, as Government Relations Chair, Skip Daum and I combed through a number of bills that came out of the legislature, both the Assembly and the Senate, and combed through all these bills and whittled them down to about 75 bills that we followed with the ASA General, the GR Committee, the Government Relations Committee, and then with the board as a whole. And so let me just ask you, what do you think? How many bills were introduced over the 2011-12 legislative session? Well, if you guessed C, you guessed correctly. There were 4,356 bills that we looked at to see what the impact would be on contractors in the state of California. And we whittled that down to about 75 bills that we followed, scrutinized, and decided whether or not to take positions on. We took positions on about 30 bills. And if you want to know how we fared on our positions on these bills, there's a nice recap on the ASAC website. I've given you a site there at the bottom. It's on the home page on our website, and it gives you an indication of the bills that we supported that the governor signed. There were about 5 of those, and then 3 bills that we took adverse positions on that he signed anyway, or that he voted, and then that we took support positions on that he vetoed, and then 1 that we opposed that he vetoed as well. And there's more detail on those bills on the website if you're interested. Now, let's go to our first bill that we want to talk about, and this is indemnity reform. You may have heard something about this already, and this is SB 474. It was actually signed last year in 2010, and they gave us a 2-year period in which to get ready for the true or false. General contractors in California may legally require subcontractors to indemnify them for their own active negligence. True or false? And it looks like we have frozen up here a second. There we go. Okay, well, it's actually true. As of today in California, this is a Type 1 indemnity clause that authorizes general contractors to require from subs to protect the general, even if the general has been actively negligent in causing a personal injury or property damage. Of course, that's what SB 474 is all about until January, or in January of 13, Type 1 indemnities are no longer available in California for most commercial projects and most residential projects as well. If we can get the next slide. Okay, the purpose stated in the bill itself is to make construction businesses responsible for losses they cause on commercial construction projects. It's actually quite broader than that. It applies to public and residential as well. It does that by removing the ability by these contractors, be it a general contractor or a subcontractor, to obtain indemnity for their own active fault from people downstream. It makes unenforceable indemnity clauses that would pass on that liability. It also limits the contractor's right to require insurance coverage as an additional insured from subcontractors and suppliers. on their insurance policies. Now, there's some controversy among the lawyers that have reviewed in detail SB 474. Some believe that the classic gold standard additional insured endorsement, the 2010-1185 ISO form, which does allow full coverage for the general contractor as essentially the same as a named insured on the subcontractor's own insurance policy. Some believe that that still is available under this law. My opinion is that if subcontractors push back and use SB 474 affirmatively and say, look, I'm not going to supply that endorsement, and you can't enforce a clause that requires me to provide it, I believe that the courts will find in favor of the subcontractor on that. I know this is going to raise a lot of questions for you, and we'll talk about digging into this further in just a minute. It also limits the contractor's right to require a defense for the contractor's own active negligence. So we have the indemnity side being limited and the defense side being limited. A general contractor can only require a defense proportionate to the extent of the damage or harm caused by the subcontractor or the supplier. And so it cannot include defense attributed to the general contractor's own active fault. I believe that defense and insurance can both be required for the general contractor's vicarious liability for the acts of a subcontractor or supplier, or for passive negligence by the general contractor in failing to prevent damage caused by subcontractor or supplier, but not for the general contractor's own active negligence. By the way, as you can see, we're going through these bills quickly. I'm just going to give you an overview here, because any one of these bills we could spend a whole day picking apart and getting all of the details and how the bill applies and what ramifications it will have. But my purpose here today is just to give you an overview, let you know that it's out there, and to the effect that it has an impact on you, I'll try to highlight how that might happen and what you might do about it as we go along. Back to SB 474, this law applies to new contracts signed after January 1, 2013, but also to amendments, which includes change orders that are signed after January 1, 2013. So if you sign a change order, does that mean that it invalidates a Type 1 indemnity clause that was in a contract that you signed before January 1, 2013? I don't think so. My reading of the bill suggests that it would prevent a Type 1 indemnity clause from applying to work done under a change order signed after January 1, 2013. That may actually be difficult to apply in practice, however, sorting the difference between damage caused by change order work versus underlying contract work, but that will need to be resolved by negotiation or through the courts later. Now, for analysis and discussion of SB 474, I've prepared a law note on our blog. It's at this page. This is a live link in the PowerPoint slide if you want it, but if you go to my website, if you type in SB 474 in the search function there, it'll take you right to that page. Now lastly, on 474, we are going to take a webinar time on November 21, an hour and a half set aside just for going through the details of 474, how it applies, to whom it applies, what it doesn't cover. There are 13 exceptions to this, and how general contractors might get out of it. We'll go into those kind of details in the next webinar. By the way, speaking of next webinars, as of July 1, 2012, a massive rewrite of the lien laws will go into effect, or went into effect in California. That included changes in all of the lien waiver forms, the claim of mechanics lien forms, stop notice forms, bond claims, et cetera, a wide sweeping change in the law, reorganization, renumbering, and so we are going to do another webinar on that. I believe the date is December 7. Same thing, noontime from noon till 1:30. We'll have a link to my website. There's already forms up there on my website that comply with the new law and has an explanation of what the changes are. Okay, retention. This is an important area for contractors and subcontractors in California. How much money and for how long can a general contractor hold from a subcontractor a portion of the progress payments, typically 10% in California. And so we do have some retention reform already in place with SB 293 that went into effect in January of this year, limiting to 5% retention on public works projects. This one, AB, and by the way, there's a law note on SB 293 on my website also. This bill, AB 1671, deals with Caltrans. Now, unlike other public entities in the state of California, Caltrans is prohibited by a bill that's the ASA helped enact several years ago, prohibits Caltrans from withholding any amount as retention from progress payments. When that bill was first enacted, it had a sunset clause and would expire end of December of 2013. AB 1671 extends that sunset for another 5 years to December 31, 2019. So that zero retention will continue. Now that's a good thing because, hey, if it works for Caltrans, how come it doesn't work for the rest of the state of California, which is at 5% in public works, and how come it doesn't work for private works? With this new legislature full of Democrats who care, hopefully, about the little guys like the subcontractors, maybe we'll be able to use this bill to get a zero retention for the rest of public works and perhaps private works as well. There's some good language in the bill that made some findings. Part of the reason the bill was going to sunset was they asked the Caltrans folks to give a report about their experience of going with zero retention, and that report came back favorably and supported the extending of the sunset. In the bill, the legislature declares that 0% retentions have had such a positive impact on contractor viability and employment during these difficult times. It also has increased competition through viability of contractors that have benefited from 0% retentions, ensures that Caltrans receives the best prices on all of its construction work. Those are strong pronouncements by the legislature that ASAC will grab onto in this next legislative session. Hopefully we can expand it to all of public and private as well. Now we have another bill that's workers' compensation reform. This is a big effort by a lot of players, and we have SB 863. This bill is 119 pages. I've just listed in summary form some of the changes in the bill. And one estimate is that permanent disability benefits will be increased by an estimated $750 million per year. How in a tough budget time can we increase compensation disability benefits by $750 million? Well, the balance of the bill is supposed to help keep down premium costs by cutting graft out of the operation of the workers' compensation system, getting people back to work faster by putting in big money into a return-to-work program, recasting how people get permanent disability payments, dispute resolution procedures, re-educating people with permanent disabilities, et cetera, et cetera. There's a lot of people in the workers' compensation arena that will give you more detailed and better analysis than I have here, but just know that it's out there. As far as the average contractor out there, I don't know that it's really going to impact your business too much as far as what you do with workers who go out on claim, other than it will affect your premiums. So how will the workers' compensation carriers respond to this bill? Interesting question. We have a split. According to the San Francisco Business Times from a couple weeks ago, they note that the compensation insurers split on cutting or raising. And they got this information from rate increase or change requests that were to the insurance commissioner, and Liberty Mutual asked for an increase of 21%, where the state fund says that they're going to be able to decrease their premiums because their costs are going to go down by 7%. 21 others are asking for increases of 7 to 14% or even more. So on balance, if you're with the state fund, your premiums may go down, but if you're with a different major workers' comp carrier, your rates are likely to go up. Now we'll talk about another bill dealing with insurance, is AB 2219. This is sponsored by the Union Roofing Contractors Association, otherwise known as IRCA, and they are dear friends of ASAC and strong supporters of ASAC, and we came out strong in favor of this bill, and it deals with the insurance that is required by roofing contractors. Most of us obviously are roofing contractors, but it does show what determination can do as far as getting favorable legislation that goes to your particular contract. Unlike other contractors, roofing contractors must have workers' compensation coverage even if they swear out that they have no employees. Why is that? Well, we know after extensive experience that there's a lot of roofing contractors that claim to be self-employed and have no employees, and yet have you ever seen a roofing company re-roof a house with just a single guy? Obviously there's some untruthfulness going on around, and so acknowledging that the law says that if you're a roofing contractor, you have to have workers' compensation coverage, period. Now, another part of this bill that the roofing contractors got is that the insurance carriers now can't do an audit by telephone or send a piece of paper to the roofing contractor to complete in response to, you know, what total wages did you pay, et cetera, so that they can assess whether appropriate coverage was provided. Now, the bill requires that the comp carriers must go in person to audit the roofing contractors' books. Now we have another bill, AB 1794. True or false? The Employment Development Department shares employee information with the state comp fund to ensure companies provide workers' comp for all employees. Is that true or false? Remember that all of our payroll information gets funneled to the EDD so that they know the proper employment taxes have been taken out. And it would be wonderful for the state compensation fund to have this information to see whether or not what's reported to them is the same as reported to the EDD. So does the EDD share that information with the state comp fund? No, it's false. However, AB 1794 does now authorize the EDD to provide that information to the Joint Enforcement Strike Force on the underground economy, the CSLB, and the State Compensation Insurance Fund. What this is doing is sharing information about employment with agencies so that the laws are being followed, one, for the benefit of the workers, but two, is to take away a benefit to the cheaters. If they don't have to pay or don't pay workers' comp, and if they don't withhold employment taxes, then obviously they have a competitive advantage and can do contract work more cheaply than those that actually comply with all of the laws. And so the Joint Enforcement Strike Force is working with other agencies to weed out the cheaters, and how they're doing this is by sharing of information. There's a couple other bills that have addressed this very issue, and we'll talk about some of those as we go along. This bill is authorized for a trial period. We'll see how it goes through the end of 2018. If they've had successes in weeding out cheaters by then it will probably be continued. If not, then they'll regroup and figure out something else to do. SB 691 is a similar bill about sharing of EDD information. This goes to the CSLB and the Agricultural Labor Relations Board. Again, for the purpose of ensuring that workers' comp is properly provided and workers are taken care of. And I believe also the CSLB is looking for this information for people that are doing construction-related work but actually aren't licensed with the state of California. See, did we lose? Okay. Now we have an employment law that contractors care about. There's a number of employment laws that I'm not commenting about because you'll be picking up employment law changes from your other sources, but as may impact contractors, we have to watch out for minimum wage to make sure that all the workers are getting the appropriate minimum wage payment. Now, under AB 240, workers have the right to get what is termed liquidated damages, a set amount, by bringing a complaint to the labor commissioner, who will then cause an investigation and possible award of damages against the non-paying or underpaying employer. Here's another one. This one is particularly important to home improvement contractors who use commissioned salespeople to go out into the field and rustle up business. Previously in California, you could have a employment for commission-based workers on a handshake. No longer under AB 2675, a commission-based employment agreement must be in writing. And that contract must specify in writing how the method is computed and paid, by which commissions are to be computed and paid. So the formula for deriving the commission amount must be specified. Also, the employer must give a copy to the employee and must get a signed receipt from the employee acknowledging that he got a copy of the written contract. I've dealt with the requirement for written contracts in another context with respect to commission salespeople for manufacturers, and this law is modeled after that. Essentially, if you don't have a receipt from the employee saying that they got a copy of the employment agreement, it doesn't exist. Now, periodic payments of a percentage of amounts generated or business generated, if it's a bonus, this law does not apply to. So if you make a verbal promise to an employee to give him a bonus if he generates X dollars of construction business for your firm, that doesn't have to be in writing or comply with this rule. But if he doesn't earn a certain amount of compensation because he doesn't make that threshold, then this law does apply. That would not be considered a bonus, and so it has to be in writing, signed with a receipt. Now, interestingly, the bill for the manufacturer's commission salespeople has an attorney's fees provision which encourages the employee to sue on a unwritten commission agreement, whereas this bill, AB 2675, does not have that amount of teeth in it. Now we'll talk about a couple of bills regarding licensing. In California, do construction managers have to be licensed? What do you think? Not currently. However, now we have AB 2237, and construction managers must be licensed to do home improvement contract work. Well, how do you tell what kind of construction management work requires a license? The bill tells us that if you provide a bid or you arrange for and set up work schedules, or if you maintain oversight of a construction project for home improvement, you must have a license. Now, this is a big deal because in California, if you don't have a license and do work that requires a license, that violation is subject to criminal and other penalties. The CSLB can prosecute you for doing construction work without a license. Now, hand in hand with the last bill, AB 2554 extends the CSLB jurisdiction to include licensees whose licenses have been revoked. The prior argument was, well, you took away my license, so you don't have jurisdiction over me because you have jurisdiction over only licensees. I don't have a license anymore, so you don't have jurisdiction over me. That loophole was successfully used by contractors who had their licenses revoked, but nonetheless went forward and did contracting business. I'm looking here at our chat and I don't see any questions. That's fine, but if you do have questions as we go along, feel free to bring them up. So the CSLB can now prosecute those that have revoked licenses, and I'm not sure what the penalties will be. They can't take away your license, which already has been taken away, but it may, there may be fines and prohibitions, other prohibitions about working in the construction area that may apply. We've got a couple of bills related to vehicles and used in the state of California in construction. This one, SB 341, may impact some of you if you have some large vehicles over 14,000 pounds gross vehicle weight rating. They need to have backup alarms that go on automatically that can be heard for 200 feet. And this is for any construction vehicle carrying materials to or from a mine. Probably not many of you do that, but to or from any construction site. It's for those larger vehicles. And essentially, if you don't have that backup alarm on such a truck and someone gets backed into by your driver, essentially that will be a strict liability finding that you are liable regardless of whether your driver reasonably didn't see the person or thing behind him. Okay, this one I should have hit the photograph here. California is one of the only state that I know of that has now authorized the operation of autonomous vehicles on public roads. I had this vision when I first saw this of these cars racing around on the streets of California with no drivers in them, or drivers asleep in the back seat because they're robotic and automated without the inputs of actual drivers. But we live in California, the progressive state, and now there is a bill authorizing, a law authorizing manufacturers to test these vehicles on the public roads. There are some limits, of course, some protections. This is for testing purposes only. There has to be a licensed driver on board, so don't worry. This person has to be in the driver's seat. He's got to be awake and monitoring and capable of taking over control if needed. We don't have to worry about the runaway race car on our streets, at least for the short term. Now we have a couple of bills dealing with public works, and we see mobile classroom units all over the place, and frequently on school sites, public or private. But when those units are on public property, do the public works laws apply to those? There's a lot of money that's gone into the construction and transportation and installation of those modular units on public school property. Not until January of 2013 do the public works laws apply, but now they will. And this is important for subcontractors and others who deal with the construction and installation of these modular units, because these units are now included in the public works definition, because the definition just now includes as, quote, installation, the assembly and disassembly of these units. And that includes modular classrooms. And importantly for contractors, subcontractors in California, it makes the prevailing wage and listing laws apply to contractors who are engaged to construct and install the modular units. Now this one, AB 1565, deals with who can bid on school district jobs. And school districts are empowered to use questionnaires and a uniform system of rating bidders so that they can ensure that qualified contractors are bidding on the work. Now this bill requires these questionnaires and uniform rating of bidders to comply with a standardized questionnaire and model guidelines that will be developed by the Department of Industrial Relations. So what we're going to find is that a standard list of questions and financial requirements that will be consistent throughout the state of California so that you don't have to relearn the requirements for every single different school district if you are going to bid on those projects. However, it continues to allow the school district to pre-qualify or even disqualify subcontractors based on their answers to the questionnaires. They can set certain thresholds for experience and financial capacity to allow somebody to bid on their project to reduce the risk to the district of a subcontractor default. This applies to general contractors, but also the districts may apply the standardized questionnaire to electrical, mechanical, and plumbing subcontractors as well. And also in the district's pre-qualification system, they can have other and additional requirements, but must include as a minimum the standardized questionnaire. So when bidding to individual school districts, you'll have to check what the individual school district's additional requirements are, if any. Now we have a couple of different bills on project delivery systems. We have AB 2498, and this one allows Caltrans to engage in construction manager or general contractor project delivery method for highways, bridges, and tunnels. Now, I'm not sure why Caltrans sought this bill. Maybe some of you out there know what difference it would make, and I'd be interested to have a chat comment from you. But I mean, construction manager would empower Caltrans to take contracts directly with all the subcontractors, whereas a general contractor typically would do that. I don't know why Caltrans would want to undertake the additional work of taking the direct contracts. Perhaps it's seen as a cost savings method where the cost of the construction manager may be less than the GC, and don't have to pay the GC's markup on all the subcontracts. It's not clear to me. The main concern that ASAC had when reviewing AB 2498 was, well, can Caltrans avoid the listing laws and the payment and performance bond protections by going the construction manager route? And our review of the bill suggests that the bill does not disturb the listing law protections or the payment or performance bond protections. SB 1509 it extends the authority for design, build, construction on schools and community colleges through December 31, 2019. Legislature is still supportive of using design build in that area. Now, can governmental entities do construction work without obtaining competitive bids? Seems that the government needs to be, or the public needs to be protected against the government doling out projects to their brothers-in-law or friends, family members, etc. And that's why we have the competitive bidding laws in the first place. What do you think? Well, yes, the government entities can do construction work. They can self-perform projects, and they can dole out small projects without competitive bidding. What are the dollar limits on that? AB 720 raises the force account limit, and force account being the amount that's being spent by the public entity using its own forces. They can do projects now up to $45,000, raised from $30,000. And then there's a floor under which the formal bidding requirements do not apply. Previously, projects of value less than $125,000 didn't have to be sent out for formal bids, but now that floor has been raised to $175,000. Public-private partnerships, SJR 16. This is a Senate Judiciary Resolution, SJR, some kind of resolution coming out of the Senate, number 16. And this deals with the Immigration Port of Entry at Calexico, West Port of Entry, and our California legislature is saying to the U.S. Congress that we would like you to use a public-private partnership for renovation and expansion of this port of entry. And why I'm bringing this bill up to you is that, or it's not a bill, it's just a resolution that passed. It's a message that our legislature is saying we're interested to have you, Congress, put your resources to figuring out how to do a good public-private partnership. And so this will give California the opportunity to observe and to monitor how that partnership works, and hopefully come up with a model that would work for California. Now, there are statutes on the books already for public-private partnerships. However, the concern for California and subcontractors is that there are not specified financial protections for subcontractors built into the current law. That is, unlike typical public works projects, there are no payment or performance bonds. And so the public entity is at risk for the project not being completed, and contractors, generals and subs, run the risk that there won't be enough money in the private finance partner to complete the work and to pay the suppliers and contractors who actually do the work. And so a problem with that is that it's a public-private partnership to do work on public property. The private entity will typically get a lease to operate the facility being constructed on public property with a lease term of approximately 35 years or so is typical. And so since it's public property, if you, a contractor, do work and don't get paid for it, you cannot issue a lien on the public property. The public doesn't like it for people to foreclose on its property and take it into private ownership. And so the lien remedy is not available. And if you were to issue a stop notice, who would you issue it to? You'd issue it to the financier, the private entity that doesn't have the money to pay you in the first place. So stop notices are ineffective as well. ASAC is encouraged by SJR 16 because it shows that this issue is on our legislature's radar, and they're asking Congress to be involved. And we see an opportunity, hopefully, in the coming session to urge Congress, or excuse me, the California legislature to enact payment and performance bond requirements for PPPs, public-private partnerships in California. We have a draft bill. We're already talking to legislators as potential authors for this bill and encourage that we may have a very strong author lined up and interested in this. And so we're looking forward to running with our own bill for these protections in California for the 2013 session. Let's talk about green building. We have one bill, AB 930. We have the California Building Standards Commission that establishes the building code for the state of California. And with CalGreen over the last couple of years developing and encouraging, requiring green building to be implemented through the building code, you would think that the Building Standards Commission would have someone knowledgeable in sustainable building design, construction, and operation already, but now AB 930 requires at least one experienced person be representing contractors in the development of these standards. ASAC is always very interested in supporting educational bills. This one, SB 1070, extends the Career Technical Education Pathway Program through 2014. And what this program does, it's requiring and creating a coalition to work to have high schools and community colleges work together to create career technical education programs like auto shop and wood shop, so that students who don't learn well from books, who would rather work using their hands, have opportunity and pathway to be educated in those areas, to find meaningful careers and not just be shunted out of the California educational system. And so ASAC supported 1070 and will support numerous other bills like it. Okay, now that wraps up all the bills that I had planned on, and we fell short of an hour by a couple minutes. I'm sure that'll disappoint you terribly, but let me see. I have a note here. I have a note here from David Mendes of ASAC, who notes that MAP 21 legislation enacted at the federal level, which ASA national supported, includes a provision that United States Department of Transportation should study and create model 3Ps or PPP contracts. And so this is already on Congress's radar. ASA National is monitoring and working on it to support it, and we will wait with bated breath to see what United States Congress comes up with on PPPs. Hopefully it'll be something that we'll want to replicate in California, just like the Miller Act federal resulted in the California Little Miller Act with the payment bond protections here. Well, with that, I will free you to go back to the remainder of your day. I will look forward to having you folks back. If you would like to discuss in detail SB 474 and its impact on the indemnity laws in the state of California. And until then, have a great day.
Dan,
thank you.
Thank you so much, Dan. This is David Mendes. And yes, I put that note in about the model P3 contracts. Thank you for the overview today. Does anybody have any final questions which you could type into the chat or the question box there before we conclude today? While you're thinking of your questions and typing your questions, I do want to remind everybody that if you registered for the series, this is a three-part series of webinars, and the next one will be on November 21st. And the topic of that webinar is how California's new anti-indemnity law will protect subcontractors. That's going to be at 12 p.m. Pacific time, of course. Let's see if we have any additional questions. And again, thank you, Dan.
And you see on the screen right now is my email if you would like to get a copy of the slides or my law note executive summary on the laws that we just talked about.
All right, I don't see any other questions at this time. So there's Dan's email on the screen. And again, Dan, thank you so much, and we look forward to your webinar on November 21st.
Thanks, Dave. My pleasure.
Thank you.
Bye-bye.
Bye-bye.